Hey guys, welcome to the Field of 68 YouTube channel. If you like what you see here, hit that subscribe button and you'll get more college basketball content just like this.
Mitt Winter at Winter Sports Law on Twitter. He's an attorney at Kenny Hertz Perry LLC, an NIL attorney, and he was a Division I basketball player for William and Mary. Mitt, it's great to have you with us tonight. So explain to all those fans and followers of college basketball in more basic terms what this ruling is about and what your reaction and thought process is to what transpired this afternoon.
Yeah, first of all, thanks for having me on, guys. Appreciate it. So at a basic level, this ruling means for at least 14 days, if you're a multi-time transfer who previously would have needed a waiver to be able to play right away, you don't need that waiver and you're able to play. So that's the basic part of it. In addition to that, some of your listeners might be familiar with a rule the NCAA has that's called the restitution rule that says if you play subject to a court order and then that court order is later overturned, the NCAA can still punish the school and the athlete that played. The court order also enjoined enforcement of that restitution rule. So if an athlete plays within this 14-day window and then that order is either overturned or a preliminary injunction, which is a longer term, doesn't get put in place, the NCAA can't punish the athlete for that happening. So if I'm advising a school or a coach who has a multi-time transfer who doesn't have a waiver yet, I would tell them to play those athletes. The NCAA has also said, I think a few hours ago, if an athlete plays a few games and then it turns out that the TRO goes away and a preliminary injunction doesn't get entered, they're not going to count that as the guy's year of eligibility if he plays like 2 or 3 games. So it's almost a situation where if you're a multi-time transfer, you don't have your waiver, there's no risk in playing.
So, Mitt, I guess the natural question to follow up on that is, look, none of us have an exact crystal ball, but when this gets brought back up in 2 weeks, what do you see the future holding and what determines it?
In my opinion, the court is going to enter a preliminary injunction, which is an injunction that would be in place for the entire time that the case is proceeding to a final decision. And the reason I say is one of the factors that the court has to look at in granting a temporary restraining order, which is what the court entered here, is whether the plaintiff, who in this case is the 7 states that brought this lawsuit against the NCAA, whether the plaintiff has a likelihood of success on the merits of its claim. And so to grant the TRO, the federal judge had to look at that, and he said, I do think that the 7 plaintiffs have a likelihood of succeeding on their antitrust claim against the NCAA. And that same factor is something that has to be analyzed in granting a preliminary injunction as well. So the fact that the court already found that the plaintiffs have a likelihood of succeeding on their antitrust claim against the NCAA, I think tells me as an attorney that this judge is probably likely to also grant a preliminary injunction, which is the hearing that's going to happen on December 27th, is to determine whether that preliminary injunction is going to be entered. And another thing that is going to do that is, so today the hearing, I listened into it got done about 12:45 Eastern. The judge told everybody to go to lunch. It said, come back at 1:30 and I'll give you my ruling. He did that. He gave his ruling. And then a written order was put out on the court docket system shortly after that. And it was a 31-page order. So there's obviously no way he wrote that in 45 minutes. He already had that before the hearing. So he already knew what he was going to do before that hearing today, which is another indicator to me that he's probably going to grant a preliminary injunction as well, which would mean that you're going to have this same order that's in place now with the TRO, allowing multi-time transfers to play without a waiver for at least months, possibly a year. So you're talking about going into next basketball season, football season, all of that.
Mitt, before we let you go, as a guy who played Division I hoops and now in your career in law, how much does it come to your mind, and at what point do you think that the NCAA is just a playing rules and championships association versus a governance association?
Yeah, I think under the current state of the law right now, and I mean, the NCAA will tell you this, it's hard for them to govern right now because all of the rules that they put in place get challenged under antitrust law. In my mind, if they want to continue on as a governance association, what needs to happen, and a lot of people are not in favor of this, at least right now, but I think it's the way, if you want to have rules around player compensation, whether that's NIL, payments from collectives or direct payments from schools to athletes, or rules around player movement like transfer rules, you're going to have to collectively bargain with the athletes, because if you do that, the rules that are collectively bargained are immune from antitrust law. So if you look at pro sports, that's why in the NBA, they have a draft, they have a salary cap, they have rules around free agency. The reason they're allowed to have those rules is because they're collectively bargained between the Players Association and the league. Otherwise, those rules would violate antitrust law. So I think for college sports and college basketball specifically, to move forward with certainty with rules like that, in my mind, that's probably the best option, which is different than the way the model is now, and it would take a lot of changing and thought by a lot of people. But in my mind, that's the way to make that happen.
Mitt Winter. Follow him on Twitter, X at Winter Sports Law. Mitt, we appreciate you staying up late with us and joining us on After Dark. Thank you.
No problem. Thanks, guys.
There he is. Okay, so we get the perspective there from someone who's studying all of this and dove into things. Let's get the coach's perspective. Chris Mack, when you're looking at this whole situation, where do you want to go with it? What's your thought process with transfer waivers and all that?
Well, just listening to Mitt, I don't know if there's necessarily a way for coaches to go a certain direction with it. It seems pretty clear, especially over the next year or so, that multi-transfers are going to be allowed, or in this case, aren't going to be able to be stopped by the NCAA. The hard part is, there were a lot of coaches in this offseason that elected not to go after certain kids because they decided to transfer for a second time. And, there were other schools that said, hey, we're going to go after them and try to file let's face it, some of them said we're going to file a bullshit waiver and see if we can get it through. And a lot of coaches knew that it wasn't necessarily on merit. But, those schools and those coaches get rewarded with a really good player that, has found his final home, I guess. Maybe not even final home now that you can just transfer as many times as you want. I don't know. From a coaching standpoint and a team building standpoint, it's really hard to see it being a good thing for college basketball.
Thank you for watching The Field of 68. If you've enjoyed what you've seen here, hit that like button, share this link with your friends, or check out the description for some other places that you can consume Field of 68 content.